Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. This is an application filed by original accused in Ahmedabad City Sessions Court. Stop. The applicant was charged under Section 302 of the Indian Penal Code for intentionally causing death of one person by giving blows on his head with an iron pipe and fracturing his skull. Stop. The City Sessions Judge Ahmedabad, after regular trial, convicted the accused by his judgment and order of conviction dated October 14, 1963 and sentenced him to suffer imprisonment for life for an offence punishable under Section 302 of the Indian Penal Code. Stop. The accused was defended in the said Sessions case by his advocate. Stop. Para. Being aggrieved by the said judgment and order of conviction dated October 14, 1963, passed by the City Sessions Judge, the accused preferred an appeal to this court, being criminal appeal. Stop. The said appeal was filed through his advocate. Stop. The appeal was fixed for preliminary hearing under Section 421 of the Criminal Procedure Code on October 28, 1963, and the same was argued by learned counsel for the accused. Stop. A bench consisting of 2 members heard the appeal, dismissed the same summarily. Stop. A writ intimating that the appeal was dismissed and was sent to the Sessions Court on October 28, 1963. Stop. In the memo of appeal, there was a prayer for bail, and the assistant government pleader appeared only to oppose the prayer of bail. Stop. Para. The accused has now referred this application, alleging that a few days back the applicant read in the papers that counsel who was appearing for accused in murder case at Delhi was truly that person who represented himself to be an advocate and appeared as such in Ahmedabad courts, and also for the applicant in Sessions case as well as in the appeal, and that he was not a lawyer at all. Stop. He further alleged that after it transpired that said person was not a lawyer, a fresh trial was ordered in murder case on the ground that the person appearing for the accused was not a qualified lawyer, and that a trial in which the accused were defended by a person having no qualification was no trial at all. Stop. The applicant further alleged that if he had known that said person was not an advocate, he would not have engaged him as his advocate for the Sessions case and also for the appeal. Stop. Said person, not being an advocate, was incompetent to defend the applicant. Stop. He practiced fraud on the court and on the applicant, appeared as an advocate for the applicant in the Sessions case as well as in the appeal, and thus deprived the applicant of a valuable right to have legal assistance in his trial, and this, according to the applicant, had led to a serious procedural defect which resulted in failure of justice, vitiating the whole trial. Stop. The applicant further alleged that there was no fair trial in the eye of law, and his defense was materially prejudiced in view of the fact that the person who conducted the matter was not an advocate possessing requisite qualification or skill to defend the applicant, particularly as the offence alleged was a serious offence punishable under Section 302 of the Indian Penal Code. Stop. Ordinarily, when an accused is unable to engage a lawyer of his own, he is always provided a lawyer by the state at the state expense. Stop. According to the applicant, this resulted in miscarriage of justice and incurable defect in procedure, vitiating the trial itself. Stop. On these allegations, the applicant prayed that the order of summary dismissal passed by this court in criminal appeal be set aside, and it may also be ordered that the judgment and order of conviction passed by Sessions Court in Sessions case be also set aside, and an order of retrial may be passed. Stop. Para. This application has been preferred under section 561A of the Criminal Procedure Code. Stop. A rule was issued by the court and the matter has now come up for final hearing. Stop. Para. The questions which arise for our consideration are that whether the High Court has jurisdiction to review its own order of summary dismissal passed in criminal appeal. Stop. Whether the application which is preferred by the accused is within the period of limitation, and whether the evidence on record is sufficient to enable this court to review the order of summary dismissal passed in criminal appeal. Stop.